Hi, and welcome everyone. I am your host, Professor Tuck, and today is Constitutional Monday. Some of you guys are not familiar with the survival broadcast. I am your host, Professor Tuck, and every Monday we talk about the Constitution, what's going on with it. We do a deeper dive into it, a deeper understanding of what's going on with the Constitution. And if you are part of the green room, we would normally start the discussion. We actually, in the green room, we were having a deeper discussion about the origin of natural law, which is kind of what we're going to be talking about today. We talk about our rights. Most of us think that our rights come from government, but they actually come from a higher power. If you ever listen to or read the preamble to the Bill of Rights, you will hear a certain phrase. All men are endowed with certain unalienable rights from their creator or by their creator, which means this is a recognition of natural law. And what is natural law and how does it play into the Constitution? And most specifically, how does it play into the Bill of Rights? And that's really what we're going to talk about, because when when you hear phrases like "we hold these truths to be self-evident," are they still self-evident truths, or were we wrong back then? So today's Constitutional Monday isn't just another dusty legal lesson. And just so that you know, I am not a lawyer. I am not an attorney. If you are seeking legal advice, please go to an attorney. I am not one. This is purely for entertainment purposes only. So, it's a reminder, or maybe even a warning, that the foundation of your freedom doesn't begin with courtrooms, classrooms, or congressional debates. It begins with something much older. It's called natural law. The idea that your rights aren't permissions handed down from bureaucrats, but truths embedded in nature itself, granted by the Creator, not by the state. So let's rewind the tape to get our bearings. The Constitution didn't come out of nowhere. It followed a war. It followed blood, betrayal, and the very real experience of tyranny under an empire that thought it could tax, censor, and surveil people without accountability. After the revolution, when the ink dried on the Constitution, there was still one problem. The people did not trust it, and rightly so. They wanted guarantees, not government suggestions. That's why the Bill of Rights was born. But there was a part that nobody talks about, not in schools, not in media, not in Congress. The preamble to the Bill of Rights. Yes, there is a preamble, not to the Constitution, but specifically to the Bill of Rights. And it sets the tone for everything that follows. And here's what it says: the convention of a number of the states having, at the time of their adopting the Constitution, expressed desire, in order to prevent misconstruction or abuse of its powers, the further declaratory and restrictive clauses should be added. Translation: the people didn't trust government power just to stay in its lane. They wanted restrictions. They didn't want loopholes. They demanded declaratory and restrictive clauses, meaning clear lines in the sand that say this is off limits, period. So let's let it sink in. The entire Bill of Rights exists not to grant rights, but to restrict government from violating the rights that you already have. So what kind of rights are these? Here's where most Americans get tripped up. They think rights come from laws, from elections, from policy, from paperwork. But that's backwards. The founders didn't invent rights, they acknowledged them. They didn't create liberty. They recognized it as something that you already possess by virtue of being human. This is where the natural law enters the chat. So natural law is older than any government. It's not written by politicians. It doesn't change with trends. It's rooted in the observable order of creation, in logic, in morality, in the undeniable reality that you were born free. And any system that treats you otherwise must justify itself, not the other way around. Thomas Jefferson, John Adams, and the rest of the founding crew didn't stumble onto these ideas by accident. They just studied them. They read Cicero, Locke, Blackstone, Montesquieu. They saw that throughout history, whenever human laws ignored natural law, tyranny followed. Natural law says that you own your body, your mind, your voice, your labor, your thoughts, your conscience. not because of some court that ruled on it, but because you exist. Full stop. Just because you're human, because you were created by your creator in some form or fashion, you have certain rights that were given to you upon your very existence on this plane. So when the Bill of Rights was drafted, it wasn't adding rights. It was fencing off government to keep it from trespassing on your natural ones, the most important ones, because they even say within that as well is that they understand that these are only the most important rights, but there are many rights that you get that are not being put out there. So if you remember the Freeman movement, back in the late 2000s, early 2010s, they would actually come out with this big old piece of this big old thick binder of a Declaration of Rights because they took it and they went a little too extreme on this. Okay. You don't need a Declaration of Rights. You need to understand what your rights are. You need to understand what a right is, and you need to understand how to enforce those rights. Because if you don't know how to enforce a right, then you don't have a right. So to stand up and say, I have the right to free speech without actually knowing how to enforce and observe the right of free speech, then you yourself do not have free speech. And the preamble, it tells you why that fence was necessary in the first place to prevent abuse, corruption, and power creep. Now, let's talk about the Black Robe Brigade because these guys were very, very important in the ideology and the thinking of the time that would form first the Articles of Confederation and then later the Constitution. The preachers and pastors who didn't just sit on the sidelines during the American Revolution, they were some of its most vocal, dangerous, and well informed participants. British generals feared them because they understood that a people who believed their rights come from God are impossible to control. These men in black clerical robes preached about natural rights from their pulpits. They didn't separate politics from faith because they understood that true freedom requires moral clarity. They taught their congregations that resisting tyranny wasn't rebellion, it was obedience to God. So let that marinate. They believed obedience to God meant disobedience to tyrants. So they didn't just talk, they led militias, they armed their flocks, they turned sermons into rallying cries, and they grounded every argument not in some party platform or trending ideology, but in natural law, in the unshakable truth that human dignity cannot be negotiated. Now, here's where the cold reality hits. Today, most people don't even know what the preamble to the Bill of Rights is or that it even exists, let alone why it matters. They've been trained to think rights are whatever is trending on cable news or in a court ruling. They think censorship is okay if it's done by the right platform. They think surveillance is acceptable if it is sold as convenience. And they believe that unless your freedom is on a government document somewhere, it must not be real. But we've lost the plot because once you forget that your rights are inalienable, meaning that they cannot be taken, transferred, or voted away, then government power becomes unlimited by default. That's the danger of forgetting the preamble. You stop seeing the Bill of Rights as a warning label for power and start seeing it as just another policy menu. So let me put it like this. If your rights come from government, then government can take them away. But if your rights come from your creator, not then no judge, no agent, no president, no artificial intelligence algorithm can override them. At least not without committing moral violence against the natural order. So we're in a time of increasing centralization, AI governance, biometric surveillance, digital IDs, speech regulation. These are not hypotheticals. These are present realities. And if we don't anchor ourselves in something beyond man made authority, we're setting ourselves up to be ruled, not represented. Natural law isn't just a concept, it's a compass. It's what keeps freedom from becoming just another slogan. It's what inspired every word of the Constitution's original amendments. And it's what the founders trusted more than any future Congress, court, or president. That's why Constitutional Monday isn't just some gimmick. It's a weekly reminder that you don't have to wait for permission to be free. You already have. The real question is, whether you'll defend that truth when it's inconvenient. So in today's broadcast, we're going to pull back the curtain. Not just one text of the Bill of Rights, but on the spirit behind it, the deeper law, the law that can't be repealed, edited, or overturned by a 5-4 decision. Because if we want to build resilient communities, off grid homesteads, parallel economies, or sovereign media networks, we have to understand what we're preserving. This isn't about nostalgia, it's about clarity. We don't need to restore America by repeating slogans. We need to remember why the idea of America was revolutionary in the first place. Because it said your rights are not for sale, not negotiable, not temporary. They're yours because you're human, because you're made in the image of your creator, because natural law says so, and no government anywhere has the moral authority to say otherwise. So now that the groundwork has been laid, I want to riff a bit on this idea of natural law and in today's context, from AI policy to digital IDs, from criminalization of dissent to reshaping of education. But we really want to get into the natural origin of natural law to begin with. So for those of you that are here listening and watching the broadcast, I want to say thank you. If you are a subscriber, this is for the free subscribers. If you're just a regular subscriber, you have the opportunity to chat as long as you've been a subscriber for 10 minutes or longer. So if you started watching at the beginning of this broadcast and you subscribed, you are now free to chat about the chat. So I want to kind of get into this, and this was part of the conversation that we got into earlier in the green room, and I kind of want to bring this forward because I really want to drive home what natural law is. So Thomas Aquinas exhaustively examines the legitimacy of man-made laws and whether they should be obeyed in a book called Summa Theologica. He asks, "Do man-made laws have to be obeyed?" His answer is no. A law only needs to be obeyed if it is legitimate in three ways. First, the purpose, which means the law must be for the common good. Number two, the author. It must be in the scope of the authority making the law. And number three, the form. And its burden should be equal and apply to all. Right now, the current system that we live under, this is not applying to all. This is applying to specific groups. If you've got this skin color, this sets of bits and pieces, if you've got this, if you got that, all of a sudden you start getting special rights. And that is really where the perversion of natural law comes, because what it does is it creates animosity. I wish I was a woman so that I could just, have this and that and the other. Or I wish I was a man because life would be easier. Or I wish that, I was this, or I wish I had that. Or if I only had that, then I would fit into this special group. And that is really a perversion of what our founders originally intended. This is what they were thinking about when they, if you wonder why they would turn over in their grave, this would be why, is because we went to the most inferior law form that there is. So there is a hierarchy of law forms. Okay, you can even go search this on the internet. If you don't believe me, I strongly encourage you to go do your own research. Um, but there is a hierarchy of law, and at the very top, it is natural law, all or universal law. Then it comes canon law, which is the Catholic Church. Then it comes ecclesiastical law, and then it comes evangelical law, and then it comes common law, or excuse me, yeah, no, it comes international law, then common law, then admiralty law, and then it goes all the way down a couple more. And at the very bottom is statutory law. If you go look at every law that we have on the books, it is statutory law. So you have this hierarchy of laws that are there. And and so I say this because I want to help you understand this deeper. So I was talking to a friend, and he was saying, he never really followed the Constitution. He followed more like war history. Well, the reason why you would want to follow the Constitution, the reason why the Constitution is so important to follow to begin with, is because it was a legal contract. It was a legal document. Okay. All power resonates with the people. You hear this, but you don't understand it. So you probably understand a trust. A trust means you have a guarantor, the person that puts the money in. The trustee is the person who manage it, and then the beneficiary, that's who it's for the benefit for. So the people, the individual people, became the guarantors. The county government became the trustee for the benefit of the county as a whole, all of the citizens within the county, because they're all putting in for mutual benefit. Okay, so therefore the people do it with the counties do it with the states do it with the federal government. Why would the states want to do it with the federal government? Because each of the several states, as a sovereign state, would not be able to go out there and do international trade. They would have trade disputes, border disputes. There'd be a lot of contention. It would actually be counterproductive to the safety and security of the local population, because they'd be facing border tensions on the regular basis, versus coming into a common union where everybody agrees to a set of rules. And by doing this union, so the states become the guarantors, the federal government becomes the trustee, and the beneficiaries are the people. Okay, because we are always the beneficiaries, because we form the counties for our benefit, and the counties form the state for their benefit, but for our benefit, and so on and so forth. And so this is kind of how it all works. And so the federal government has to make sure to regulate between the states, because if you go from one state to the other state, what are the rules? How do we make sure to respect it? Because if I got a citizen in one state, but he goes into another state, has an issue, he's not going to want to do it. It hurts both states, and it becomes more isolationist. So in order to, this is where like the Interstate Commerce Act and certain clauses within the Constitution come in. Okay. And I'm telling you all of this because there was a very, very important case. It was called Dred v. Scott. And essentially, what had happened is, since I'm here in the great state of Missouri, in Missouri, it was the Missouri Compromise, and they voted to become a slave state. And as a slave state, if somebody was in Missouri who decided to travel north to, like, let's say Iowa or Ohio or something along those lines, well, would his rights transfer with him? Well, according to the Constitution, they do, because that was the uphold of of Dred Scott. That was the overall ruling, is that because the guy that came from Missouri had a slave and it was legal in his state. As he traveled through the states under the Interstate Commerce Act, he had the right to freely travel and retain his rights as he was traveling through those lands. If he decided to become a citizen of that state, then he would be bound by those laws. But considering he was a citizen of a slave state, they could not legally legislate his slaves away from him, as a way to be able to, as the infighting was going on between the North and the South over slavery. And so what they ruled is that because he's from Missouri, and Missouri is a legal slave state, you have the right, as you travel through the different states, to keep your slave without the thought of losing your property, because they made your property illegal in one state but not another. And so let's just say, because for the sake of it, because I got a friend that's traveling, and you guys know me, I like my devil's lettuce. And so let's say he comes from a state that is legal. Well, what happens if he goes into another state that is not legal, and then he gets caught with a possession charge? What does he do? Well, under Dred Scott, which is a major Supreme Court decision, which actually it formed a lot of future policy moving forward. Erie v. Tonkin and Dred Scott were two of the most landmark cases ever to happen in American history, because of how it thoroughly redefined the law. Such as in Erie Tonkin, was you had a citizen of another state suing a railroad in another state, but instead of suing him in the local state court, he chose to sue them in federal court, because the federal government had rights over the different states. Okay, so that where it set up the whole thing, where we've got things like the Ninth District Court that's making its own laws that are therefore impacting the rest of the United States. And so this becomes something that just, it is what it is. But these are the long-term policy effects that came out of these decisions. And even when FDR decided to expand the court. Well, because he expanded the court, he was able to get influential decisions because they were his appointees that would help him pass his legislation, even though normally it would not be right. So over time, the courts got corrupted, and every time they talk about expanding it, it's more for political means, because we don't need more than 3 judges in reality. Having 7 judges makes no sense. Having 11 judges makes no sense. You're still going to have judges. It's just like, okay, well, we feel that the court's imbalanced and won't go with our agenda, so now we're going to politicize it. But so many people step back and they say, look, this is something that is, I have no control over it. I have no anything over it. It's just going to happen. If you're going to follow it, follow it. If you're not going to follow it, don't follow it. But at least draw your line in the sand and figure out where you're at. Well, if you're going to do something like that, okay, you got to realize that all of this is a contract. You can call it a trust, you can call it a contract, you can call it whatever you want. It's a legal agreement between the people, the states, and the federal government to operate in a certain way. And so therefore, if you refuse to vote, to participate in the political process, that indirectly becomes a vote of no confidence. You could technically collapse the whole federal government if if 60% of the country decided to no longer vote. That's why people say, oh, well, if you don't want to whatever, then you have no right to complain about it. But the thing is the reason why we're not voting is because we have no confidence in the system. The system is not here to benefit us. It is here to benefit ourselves. And so those of us that stepped out of the system and said we no longer wish to vote are waiting for the rest of everybody to catch up so that we can do a vote of no confidence, restructure our government, and build something that's going to be long-standing. But do we want the Constitution? What is the Constitution? Is it outdated? What do you think of the Constitution? How do you feel about it? These are different things that you will have to sit back and decide. Is it just a document of nostalgia? Do you not understand it? Do you not care enough to understand it? Because if you want to understand how we got here, a legal document was amended and redefined so many different times that if you don't follow the legal work, or the legal paperwork that starts at the top, you're just going to follow, because everything that is important and impactful always gets done at the Supreme Court level, including Roe v. Wade, which Roe v. Wade that was originally it was a proper decision to give the woman the right to reproduction, because under natural law she has that right. But the thing is it became politicized. It became politicized by religions, because the Christian right did not approve of abortion, for various reasons, and then the liberal left decided to take it to the extreme, until everybody left in the middle just threw up their hands and said, "We don't want to deal with this anymore." But by that time, it got overturned. And the thing is the important part of Roe v. Wade wasn't the fact that you had the right to abortion. It was the fact that you had the right to control your own body and what happens to it. Because without the Roe v. Wade decision, what it says is that you do not have the right to control what gets done to your body. I.e., if a government wants to come and take you, they can do it, and they're not violating the law. Versus in current society, if the government wants to come and take you away, to jail, take you away to somewhere else, they have to do it with your consent, whether it be implied or cooperative. You are giving consent the whole way as you go into jail, because of the way in which you conduct yourself and the way in which you submit and give them that authority. Okay, so you are submitting in some form or fashion. You are giving consent, whether you realize you're giving consent or not. It goes all the way back to even the Magna Carta. Okay, so the original Magna Carta is, they tell you that that's kind of where we get due process and things like that. But in reality, that was a void document the moment it was signed, because the nobles, because they were mad at the king for overstepping his boundaries, brought declared war on him, stormed his castle, and under threat of sword, he was forced to sign the Magna Carta. And in law, if you do not give your consent, then therefore it is not binding. And so therefore, after the king passed, what ends up happening is they have to um, is that they had to find a sympathizing noble to take the place of the king that would rewrite the Magna Carta and rebind them, because they knew that it originally wasn't bound, and the only reason why the king continued to honor it was under threat of duress. And so therefore anything done under threat of duress is no longer legally binding. Okay, so this goes all the way back to the Magna Carta. If you really want to impress a lawyer, tell them that the Magna Carta is a joke, but you better know what, I can't remember what the name of it is, but they gave it a different name afterwards. But go look at what the second version of the Magna Carta was, and if you talk to a lawyer and you kind of let him know that you know that, you might actually win some brownie points with him. Okay, so this is what today's broadcast is. If you guys have any questions, please let me know. I am more than happy to answer your questions on this subject. That's why I open it up for subscribers, not members, but subscribers, to be able to ask questions if you'd like to in the chat. If you'd like to be a lurker, go ahead, be a lurker. This is a broadcast for you to sit back and listen. It's done in podcast format for this specific reason. But I wanted to go through and I wanted to answer a couple of these, top 10 questions, um, uh, uh, the top 10 questions that were asked as far as this subject goes. So there was one question that says, why was the Bill of Rights rewritten? Or excuse me, why was the Bill of Rights written? And this is very important, because if you want to understand the history of the Bill of Rights, you need to understand why it was written. It was written. Okay, so they originally had the Constitution that was going to be that was going to be passed without the Bill of Rights. So imagine that the Bill of Rights never existed, and that you had a fight between the Federalists and the Anti-Federalists. The Federalists were monarchists but called themselves Federalists, and the Anti-Federalists were Federalists, but because the name Federalist had been taken, they became Anti-Federalist. So it became a name play. But your Federalists were actually monarchists. They were nationalists. They weren't. They did not believe in self-government like Federalists did. And so you had this battle back and forth, and they needed 9 states to be able to ratify the Constitution. And the final convention that they came to, that they needed to be able to do it, was the New York Convention. And this is why New York became such an impactful state, is because at that point in time they were willing to they were willing to what's it called? They were willing to conditionally accept the the Constitution, as long as they provided a Bill of Rights. So the Constitution was actually ratified conditionally in 1787, but the Bill of Rights, it took 2 years to write it, because they had to figure out what to do. It took 2 years to write it. So the Constitution was fully ratified in 1789, but we almost didn't get the Bill of Rights if it wasn't for Thomas Paine as the federal farmer and the other anti-federalists. We would never have had the Bill of Rights. We would not know that our rights come from our creator, that instead we would think that our rights come from government, which is what they've convinced us of anyways. That's just the way that they set things up. So if you're ever curious, like, how did the Bill of Rights, why is it so important, what's so impactful for it, why do you always talk about the Bill of Rights, Tuck? Because the Bill of Rights was a protection for the people. It was not there to protect the government. See, even the Supreme Court has ruled, because there's people that claim to be U.S. citizens, and to be a U.S. citizen means you're a 14th Amendment citizen, which means you are a citizen of the District of Columbia and then the state in which you reside in. And so when people take constitutional arguments to the Supreme Court, the Supreme Court regularly sits back and says that um, regularly sits back and says that the Bill of Rights was designed to protect the citizens of the states, of the several states, from the federal government, not the federal citizens from the federal government. So unless you can put yourself in the capacity of a state citizen and sue the government in the capacity of a state citizen, your rights are given to you by the government. So they did get what they wanted. They just had to have a civil war in order to have it happen, because this is what spun out of the Civil War. Okay, let's go on to one more question here. Um, how does natural law connect to the Bill of Rights? The thing is, the preamble to the Constitution. And by the way, Ojos Azules, gonna have to catch the replay. I like the title of Rights from God. Thanks, Ojos. So I will tell you this. So let me go back and look at the question again. Um, are rights granted by, or excuse me, how does natural law connect to the Bill of Rights? Well, the thing is it says so in not only the Constitution, but all men are endowed with certain unalienable rights. Okay, from their Creator. What does that mean? That is a recognition of natural law. And if we go back to what has been said more than 2,000 years before before the Constitution was even written, part of what actually probably inspired the Bill of Rights to begin with, as far as what formula do we use, is that it has to have purpose, it has to have the right authority, and it should be equally applied. And if that is not done, then it does not. It is an unfair and unjust law. And so the Bill of Rights and the recognition of natural law means that if you ever go into the courtroom and you bring up natural law in as your defense, you're going to have more of a leg to stand on, because it's not about jurisdiction. You were a human being before you were a citizen, before you were anything. You are a creature of nature. And by being a creature of nature, you have the ability, you have certain rights that were endowed to you, that were given to you upon the very existence. And so those rights are enumerated in 10 of what they consider the most important laws that or most important rights that should never be infringed upon. Why would you take what is the right of free speech? If I can't talk about what I think, then that means you're going to censor the way. If I can't say what's going on in my head, that means I have to censor my speech. And by over time, by censoring my speech, I now censor my thoughts, which means now my thoughts are not mine. My thoughts belong to you, because you've decided what I can say and what I can't say. And so, therefore, the importance of free speech boils down to the ability to pass through important ideas, the ability, the freedom of the press, the ability to inform people and let them know what's going on. Okay. Um, and then you've got the Second Amendment. You have the right to self-defense. Not only self-defense from an attacker, which was understood back then. We didn't need the castle doctrine, but also protection from the government, because the government too is an enemy when it violates natural law. Because the from a Christian standpoint, God created everything, so therefore everything is subject to Him before it's subject to anyone else, and so therefore you are held to God before you are held to man, and so therefore your conduct and your behavior must be equal to that of God's law, not man's law. That's a simple way to put it. You've got, not having double jeopardy, which means you can't be tried for crimes. You have the right to be able to not incriminate yourself, because sometimes you may say something that sounds wrong, but it wasn't that you did anything wrong. It's just that you were in the wrong place at the wrong time. Okay. So if you guys would like to come join me over in the green room, there is, you can come on over to the green room. It's open. We're going to go ahead and go into the after party. I'm going to sit back and chit chat with all my friends over there. I would love to see you guys come join me over there. The link is down in the description. You can go over to Patreon, and with a $5 or $10 membership, you get access to the green room. And by having access to the green room, you can sit back and have a more in-depth conversation on the subject of the day, or just kind of what's going on with you and things like that. So, with that being said, for those of you that are here in the on the YouTube side, I want to say thank you. For those of you that are in the green room, hold on just a moment as I close this out.